solve problems. And very early on, probably in our territorial days, we decided that beating each other over the head with clubs or shooting at each other was not a very good way to solve problems. And so we came up with the court system. And we, at this level, the appellate level, are reviewing cases which have already been tried. And that's the number one thing I think people don't understand. When the case gets here, it's over. It's been tried in their home county. We do not retry the case. This courtroom is unique in courtrooms in South Dakota, and it's unique for three reasons. One is it has no witness chair. That is because there are no witnesses. We do not listen to witnesses here. We simply review the transcript of what was testified to back in the home county. Secondly, there's no jury box here. That's because there's no jury. That decision was made by a jury back in the home county, and we simply review that. And finally, if you were to come to one of our oral arguments, you would find that there are rarely the parties in the dispute attending the proceedings. Usually it's just the lawyers making arguments. And while the cases can be tremendously complex, we're really only trying to answer two questions at the end of the day. One is, was there a mistake made at that trial in the other county? And if there was no mistake made, end of the appeal, it's affirmed. And if there was a mistake made, then we have to answer a second, maybe more fundamental question. And that is, was the mistake so serious that it affected the outcome or the fairness of the trial? Once again, if it did not, then you're only entitled to a fair trial, not a perfect trial. So we are going to affirm. Only if there was a mistake made and it was so significant that it affected the fairness and the outcome of the trial will we reverse. And I think there's a misnomer there because most people think, okay, the court reversed. That means the winner below is now the loser and the loser below is now the winner. That is very rarely the outcome. Most of the time, because there was a mistake made, we send it back to be retried without the mistake, and there's your fair trial.
Well, the Supreme Court is an appeals court, which means that we don't hear any trials and we don't take any cases, most cases, from some original complaint or charge. What we do is we review what other courts do. And our review involves looking at whether or not the judge in the case followed the law and whether the facts support the decision that the judge made. And I would say probably in the majority of the cases, we decide that the judge did the right thing. But there are cases where we feel that the judge made some mistake in applying the law or in ignoring some facts that should have been considered. And when we do that, then we will send the case back, sometimes for a brand new trial, and sometimes just to reconsider a part of the trial, and then make another decision with correcting the error that the judge made.
Well, the Supreme Court is different than what you probably understand a court to be, because as you look around this room, you can see there's no jury box, there's no place for a witness to sit. There's 5 chairs for the judges, and then there's 2 tables for the lawyers. And so I think people don't often understand that you don't get to try your case over again when you come to the Supreme Court. If you come here because someone alleges that a mistake was made when you had your trial in your local county courthouse, wherever it is that you live. And so what most people don't understand is that we don't listen to the witnesses again. We don't hear new evidence. What we do is we take all the records and transcripts and exhibits that were introduced at the trial level. We review those. We read the briefs that lawyers write. Each side has a lawyer or represents themselves, and they write a brief telling us what they think the law is, what the facts are, and then we review their arguments together with the record that was made at the trial, and we make a decision that either the trial court made the right decision, or that they made the wrong decision. If we decide that they make the wrong decision, then we can either, depending on the kind of mistake that was made, we can either simply say what the result should be, or in a lot of cases, we just need to correct an error of law and send it back to have another trial to correct the error.
Well, it's a court of record, and they take cases on appeal. They don't try cases like circuit court judges do, but when the trial court gets done, then a grieving party can appeal it to the Supreme Court, and we've got the automatic right of review where we review everything. We don't have to write an opinion on everything, but we can do a summary disposition and just do it by order. And the Supreme Court hears the arguments on the cases. At one time it was taking us, we were getting like 40 cases basically every 1 month or 5-week period. And since then it's dropped off considerably. But it was a real workload, and we tried to get those cases out, within 3 months. It doesn't always happen, but we would all read up on the cases in the beginning, and then we would go to peer and hear them, unless we were going out to like the University of South Dakota to have the cases heard, or some other place in the state. And we'd hear the arguments of counsel, usually 3 a day for 4 days. And then we'd go into conference and we'd argue our position and take notes. And the person who was assigned the case would then write it at the end of the term. But at the same time, we'd get another 30 to 40 cases to take home and read the briefs on to get ready for the next term. So it was just, back to back. It was very crowded, very busy. Anyway, that's basically what we did. And if we couldn't agree, if the person who was assigned the case couldn't get a majority vote, then he could write it, but he wouldn't get the majority vote. And then he could either rewrite it the way the majority wanted him to, or it was turned over to the first dissenter who is now in the majority opinion. So it was a very good, sound system. There was a comparison to some courts in the history of Supreme Courts where they called this type of a thing a hot court because we read the briefs before. But in contrast, then a cold court, they would go in and wouldn't know anything about the case, and they'd hear the arguments and then theoretically go read the briefs. Well, thank God we had a hot court, and it did get warm from time to time, but it was just a challenge,
Well, the Supreme Court reviews what the trial court did to see if everybody was treated fairly, to see if there were any mistakes made in the law or misinterpreting the facts. But it's there to make sure that the people who appeared before the trial court were properly taken care of and properly addressed.